my desire was to get in there and start trying cases. And that from that moment forward, we've tried a lot of cases. And so the results, like I said, are a combination of, in my mind, those three factors, good case, hard work, and people giving you a chance to have the other two factors count in a courtroom. But it really all goes back to the fact that I've always wanted to do this, and I've done this many, many times now. And we've had a lot of losses, and we've had a lot of, challenging cases. But I think now we're sort of hopefully getting to a spot where we start to, to continue to build on those wins for people who deserve it.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share this conversation with Scott Montgomery, a partner at Santa Rosa-based Abbey, Weitzenberg, Warren, and Emery. Scott is part of an exciting shift in trial work. For decades, the big deal trial lawyers were primarily pre-Discovery Act or former criminal practitioners. We're now seeing a wave of younger civil trial lawyers storming the courtroom doors, refusing offers that undercompensate their clients. Scott's results read like an introductory speech for a Lifetime Achievement Award. Yet, at 39 years old, he's got decades ahead to continue laying defendants low. Over the last 2 years, he's won a $46 million and a $24.8 million jury verdict for child sex abuse victims. He has already won a Clay Award for the social significance of his results. He's done this while being a father of a 2-year-old with another on the way. And we talk about the tension between parenting and a prodigious practice. So please sit back and enjoy this wide-ranging and inspiring conversation with Scott Montgomery. Welcome to the show, Scott.
Thank you.
I don't want to bury the lead in terms of some of the significance of what you've accomplished so far. Normally I go into background and other things, but one of the things that I just found fascinating about you and your practice so far is that within the last year, you've gone back to back with I'm going to see if I get the numbers right, 46 million within the last month or so in a child sex abuse case, and then 24.8, nearly 25 million in another one. And if I have it right, you're 39 years old?
Yes.
So most lawyers don't finish their career with those kinds of results. And you're trying cases in a way that is really meaningful and really impactful. And I wanted to start unpacking some of that with you. How do you find yourself able to get to trial in an era where a lot of people are saying, look, I just can't convince an insurance carrier to pay the wrong amount?
It's a good question. And first of all, thank you for the kind words. I think that, those results are a product of a couple of different things. Well, really, I think three things. And I think any case like that is a product of three things. The first is you have to have a good case, meaning you have to have assessed it. You have to know that you have a good case, or at least know that you can present a case that is morally right and that is factually correct, in my opinion. And I use moral in the sense of, not like a biblical moral sense, but do I feel good about presenting this case? Do I feel like I'm on the right side of it? So you have to have a good case. And then I think you have to do a good job. You have to work hard and you have to work smart. And I think me and myself and my team, and it's not just me, I have some great associates, some great paralegals. We have a system of doing that is efficient, it's effective, and we have a good time doing it. And I think that's really important. So you have a good case, you have to work hard and do the right thing for the client. And then, but to answer your question in terms of those results, the third factor is always just that the defense has to make some choices that are not the correct choices as well. And that answers your question is how are we getting these results? It's because of mostly that third factor that, every one of those cases, both those cases had, ample opportunities to resolve. And choices were made, whether by an insurer or by the defense counsel, that were not ultimately the correct choices. And, so we would never have gotten that opportunity absent that third factor. So, I've been doing the same thing. And by the way, this isn't to malign defense counsel, but both counsel in both those recent cases are very good. They're very qualified. They're people I like. So, when I say poor choices, it's not in the sense of that, something's doing wrong. It's just a carrier making a poor decision and through their attorneys. But I think that the way that we've gotten to these results in recent years is just by trying a lot of cases and being willing. And from the very beginning, I was not just willing and able, but it was what I desired to do, was to be in the courtroom. And so, like, if you want to go back to it, the first case I ever tried was in Napa, and I was not that far in. I think I was like just a couple of years in, and it was the first case I tried solo. Sorry, maybe I'd tried one before that. And basically everyone and their mother was telling me not to go try the case because they all knew the case. I was a couple years in. They all knew the case wasn't a very good case. And even the defense lawyer, who actually was, again, a very nice guy and who passed away subsequently, not that long after, was telling me, and I remember as a younger lawyer, I was thinking, gosh, this guy's really trying to mislead me. I like him, but he's trying to mislead me. But he's like, this is a really good offer. You really should take it. What's going on? And he was completely right. And, we went in there and I thought we were really like giving it the old college try. And we lost the case. It was an admitted liability case, and we lost on like proximate cause of any injury. It was that level, but it was kind of, that was kind of always my desire, was to get in there and start trying cases. And that from that moment forward, we've tried a lot of cases. And so the results, like I said, are a combination of, in my mind, those three factors: hard work, good case, hard work, and people giving you a chance to have the other two factors count in a courtroom. But it really all goes back to the fact that I've always wanted to do this, and I've done this many, many times now. And we've had a lot of losses, and we've had a lot of, challenging cases. But I think now we're sort of hopefully getting to a spot where we start to, to continue to build on those wins for people who deserve it.
Now, you've been at the same firm from the time you got your bar card, right?
Yes.
There are a lot of firms who would typically prefer their younger attorneys to be working cases, settling cases, that trials are not necessarily an efficient way to make money. Sounds like the firm that you're at has a different approach in terms of encouraging people, or is it just you? How does that work?
I mean, they were always encouraging, and they've always been a trial firm, and so they're always encouraging of that. But don't worry, I made them plenty of money because I just did the trials by working extra hard. I was still settling lots of cases. I mean, we're still doing the same ratios that everyone's doing. Probably 95% of your cases settle. I mean, we're not any different in that regard. But as a young lawyer, I just worked so much when I was starting out that I was able to do that. And they would let me go try, cases that weren't very good because, Scott wants to go do that one. And, he can go do it, and we'll see how that goes for him. So they were super encouraging and positive in that regard, but I definitely don't think I made them any money. So they were very on those, I think.
Understood.
So no, we were still following the same model of working depots and all that. I just put in the extra time, and they were able, willing to give me that opportunity to do so.
And I bring that up because I think for some time there was a concern that, look, we don't want to try our bad cases. If it's a low speed rear impact case, it's going to be weeks, it's going to be costs, and we're going to get a low number. Mm-hmm. We don't want to invest in that case. And yet those are some of the best cases for young lawyers to go out and learn. Totally
true. And, I think that they were just willing to let me do that. And, they're great people. I mean, I've worked with them for my whole career. I always say it's the best place I've ever worked, but I mean, there's a subtext to that in that I was a law clerk there. I never worked anywhere else. So, but they're great people. They're amazing people. Bart Weizenberg, who's, in I believe, in his 70s now, and, sort of phased out a little bit, but, Pat Emery is a really good, well-respected trial lawyer, both Abota attorneys. I don't know if they're active at this point because I know you're in Abota. I don't know if they're actually going to the meetings and stuff, but both Abota people who had gotten a really good reputation for trying plaintiffs' cases in the 70s, 80s, and early 90s with some really big wins on some really challenging cases. They were willing to do that. And then my direct mentor, I think I talked to you about this already, with my direct mentor, Mike Green, who's maybe 10 years older than me, I believe. Don't quote me on that. And he always, had kind of passed that down to me in terms of letting me be gung-ho, letting me be Scott, basically, and go do what I'm going to do, trying cases that maybe the firm wasn't necessarily going to make money on, but knowing it was good exercise because he'd been kind of given that same opportunity by Bart Weizenberg, his mentor, as I understand it, before I was at the firm. Basically, go cut your teeth on these cases and, have a great time, And when you're a young lawyer, like I say, I mean, I remember thinking, gosh, I didn't think they were bad cases. That's what's so funny about it all, is now I would look at it and go, it's not that they're bad cases. Like, people had injuries and things, but the valuations were reasonable from the insurance company. And there's never going to be a huge number you're going to get off those. But when you're in that set stage, 3, 4, 5 years in, all you want to do is get in the courtroom. You have blinders and you lack the experience to really make that determination, which is why I laugh about the attorney who literally, I remember we were in the courtroom in Napa. We were walking out in the hallway and he was like, the offer's still on the table. He was in the elevator and I was joking around. He kind of had this funny voice. He always wore a hat. And I just remember, I feel like the elevator door was closing. And this is a story I tell to people at parties or bars and things that people think is funny. And I was like, the doors are closing. He's like, you don't understand. Take the money. And the doors like closed. And he was completely 100% right. He was like my guardian ad litem, trying to look out for me, because he didn't, he was an in-house guy. He didn't really care either way. He was a very nice guy. And so I still always remember that. Take the money as the doors closed. And I should have taken the money, but it worked out in the long run. Yeah. I think it was $75,000 or something. It was, which was a pretty good offer in retrospect. In retrospect, against zero.
You listed 3 things, and I think the second one that you talked about was team. And I certainly don't want to overlook the importance of having a strong team when you're trying a case, because there may be a person who does a lot of the questioning and the strategy and other pieces. Everyone works together to make that important. I'd love to have you break down your team on the more recent cases. How did you work those up? And how is your team made up in terms of getting that ready and then presenting it at trial?
Let's just working back from the last one. And the last one, I tried with my associate, Caitlin Wright, who has been with me since her first day as a lawyer, which was about 2.5 years ago. She was paralegal before that. And she's been excellent in her, and on the case she did, any type of legwork needed. In the last case, she handled all the kind of back end stuff along with our paralegal, Haley Norton. And just to speak first to Caitlin, I'm very proud of her and very jealous of her in a way, because she has been a lawyer for 2.5 years and she's been to trial 5 times.
Wow.
And she has tried a case solo as well. And she started with me because when we gave her a job offer. She passes the bar, and I was starting a trial, like a pretty, a good DUI crash, just kind of a standard serious personal injury case with, surgeries and things like that. And she said, well, what do you want me to do? I'm starting. And I said, well, I'm not going to be able to figure out work for you to do at the office. Just come sit with me at the trial. And she sat through, I think it was 3 weeks or 4 weeks. And we got a verdict of about $2 million in that case. And I go, do you know how long, Caitlin, it took me to get a $2 million verdict? Because that was my biggest verdict at the time. I think it was 2021 or 2022. I said, this took me so long. You get it in within 5 weeks of being a lawyer. So now, she's been done all these now. And so it's kind of old hat for her, but she was integral. She did a lot of, just a lot of the work up, the writing, all that sort of stuff. She didn't question any witnesses on this one. There weren't that many witnesses, so I handled them and I did the openings and closings, but she was instrumental to all the back end processes. And then, and she does witnesses in other ones, and she had done witnesses in a lot of our other cases, including her own case, which was a sex abuse case against a chiropractor that she tried solo, and did a great job, got a great result. And then Haley Norton has been my paralegal for a really, really long time. And she's amazing, and she knows what I need before I need it. And that's important to have in the courtroom. And she knows how to work trial director and all the different programs that we use to do video playback and kind of all the different little things that I like to do. And she's just been amazing. And it's, the unfortunate part is that I think she's expressed, I think, that she doesn't plan to work forever like I do. And so I'll be really sad to ultimately lose her. It'll be a huge hit to our practice, because I think anyone who tries a lot of cases knows that the paralegal is as important as anyone else in terms of, all the different things that they do, getting everything scheduled, getting witnesses, they're making phone calls, last minute, just everything, and this, that, and the other thing, the copy service for questionnaires. I mean, you name it, they're doing it. You can't do it without them. I mean, the attorneys are important, but they're really important too. So that's really the team on that one. I had another associate who worked on it a little bit, some other staff members that help out around it, but that's the main team for that. And then on that one as well, I'm a big believer in using our resources most efficiently where we are the best. And so I do not profess, claim, etc., to be the best writer in the world. I am okay. I am good. I used to be pretty good, but definitely not the best. We use outside counsel for a lot of our writing projects. So for the people who have worked on that recent one are Tiffany Gates, who is an appellate lawyer out of San Luis Obispo, and Esner Chang and Boyer, Andy Chang, who is a plaintiff's appellate lawyer out of the East Bay. They were both integrally involved in that case, and they will continue to be involved in that case if there is an appeal ultimately and things like that. So I'm a big believer in that, and just the idea that it always takes a village to get anything done. I don't know if I told you this part of my background, but my background is in competitive sports, particularly hockey. And the thing that teaches you the most, other than being competitive, wanting to win, is that you have to have a team. There's no such thing as Steph Curry doesn't just win games solo. We've seen that. The years when it's just Steph Curry, they ain't very good. So and I'm not comparing myself to Steph Curry, but my point is just no player is greater than no team is greater than the sum of their parts. And so if you have, the desire to be really good, you have to have a really good team around you. And, I'm lucky to have that inside and outside our firm in that village and knowing where to put those pieces.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I want to follow the hockey piece for a little bit because I noticed that some of the more successful lawyers, more driven lawyers, sometimes come from some sort of a competitive sports background. Can you unpack your hockey background a little bit?
Yeah, so I grew up in Santa Rosa, and for some weird reason, my parents put me in ice skating and then ultimately hockey, and then ultimately I kind of outgrew Santa Rosa in that regard, and I went to a boarding school in Minnesota for part of high school and played hockey.
Where there's some ice, I would presume, in the wintertime.
Yeah. And for people who follow hockey, the school I was at, that while I was there, Sidney Crosby was also there. It was a place very well known for hockey. Let me be like a De La Salle for football. Like they would go around and recruit people. And Sidney Crosby went on to be, one of I think they call him the next Wayne Gretzky. They think may have been one of the greatest players of all time. He still plays for the Penguins, I believe. And so I did that. And then I went and played a year of semi-professional hockey actually after that.
Wow.
In Iowa. So I've lived a lot of different places, and that's how I know California is the best. So I lived in Minnesota. I lived in Iowa for a year, and then I got really hurt during a game, and I broke my ankle with a very severe through and through, and I couldn't really play. And so I ended up just going to college the next year instead of continuing to play the hockey trajectory, which a lot of people will do a couple years of that and then try to break into a D1 hockey school. Because when you are 18 years old in high school, you're not really, unless you're really, really good, which I wasn't that good, you're not big enough to go play at the D1 level. So a lot of guys, what I was trying to do was play a couple years of this semi-pro hockey, which is called juniors, and then ultimately try to go to a D1 college to play hockey. That injury just kind of made that unlikely. And so I went to CU Boulder, and continued to play hockey, club hockey, and really enjoyed it. And I still continue to play and really enjoy it. But it does teach you, especially when you're at the more competitive levels. Although it's funny, I kind of stopped playing recently, but for years I played in the beer league, basically in Santa Rosa. I don't, pick up, not adult league, often called beer league in hockey. Okay. Because people might have a beer before the game. And oddly enough, you wouldn't think that would be really competitive, but people are really competitive even out there. So I think that to your point, the hockey background, any type of competitive background is a good precursor in my mind to being a lawyer, because, it is something where you play the game really hard. You really, really, really want to win. But also with that, I usually don't, and I'm trying to adopt this more especially as I get older. I usually don't hate the other player after the game, the other team. You understand that you're both doing your job, and I'm trying to also, so I think that's another good thing about a sports background is hopefully makes it so you can set aside kind of the game and then your own personal thing and not, have some high level of animosity towards the other side. Like I said, I like the people I've tried cases against who have beat me, and I like the people who I've beaten generally, with some exceptions, obviously, like anything in life. So good things I think hockey has a lot of good things for a lawyer and for anyone who wants to do something competitive.
As we talk about your team, I want to ask about what I would consider to be not necessarily in-house team members, but outhouse team members. And you made reference to that as far as writing is concerned. But want to ask about focus groups and jury consulting. Do you do anything as far as that's concerned for your cases?
Yeah. So focus groups, and again, this is where you have someone like Haley, our paralegal, who's so valuable because we do a lot of focus groups. I think focus groups are super important. And Haley is kind of the person who puts all that together for us. COVID, we started doing them on Zoom. I remember we were setting up to do a focus group in person. It just wasn't an option because of COVID. So we did one on Zoom. I remember thinking, we're like, how is this all going to work? It's been the best thing because it allows you to have such a higher volume of participants. It allows you to break into rooms and have discussions. You can record it and transcribe it much easier. So, I mean, it lets Zoom, of the things that came out of COVID that were positive, Zoom focus groups and the willingness to participate in those, whereas I would have said before, absolutely not, has been a real positive. And it lets us do more focus groups as well. So we do a lot of focus groups, and they're really important. We just ran one on the case I was telling you about that we're going to trial on November 22nd. We just ran one last weekend.
And because focus groups can mean different things, do you do a plaintiff versus defense style focus group where somebody in your office or somebody from outside plays the other side?
Yeah. I mean, we try to target it to issues. So I try to figure out what do we think the issues are going to be in the case that are going to be contentious versus just like doing we used to do them when I first started at the firm, we would do them as like a whole presentation and then there'd be like a deliberation and all that. We've shied away from that because I don't think that gains as much data. Now we take the things that we believe are going to be either an issue or problematic or just that we want to test, and we focus on those while doing some degree of presentation of the whole case, but focusing on those issues. And then a lot of times we go through the verdict form, but it's kind of hard. You have to have instructions. You really don't know how it's all. But so we really get people talking more with targeted questions about how do you feel about this? How do you feel about this? And a lot of times it's not necessarily like the questions on a verdict form, but people's gut reactions to concepts. Like when we've done focus groups on the required vehicle exception to the going and coming rule, something we deal with a lot, and it's a personal vehicle, but, are they using it in the scope of their employment? They're on the way home. We test things like that for issues like, well, how do you feel about that just generally versus do you think it's a required vehicle? What would make you feel different about that and really get people talking? So we can kind of assess to the extent there's a problem, we can assess the underlying root cause of why there's a problem and hopefully correct that in our presentation during the case.
Makes total sense.
So it's a little more targeted and it's different for everyone. But we do a lot of them. I mean, we usually do 3 before a trial. And on a bigger case, I try to do one early. If possible, you like everything in life. Like you want to do all these things, you don't always, but we try to do one early because I feel like if you can do it early, it really targets your discovery.
And that was something I learned from a consultant, a fellow named Ed Lazarus, who we've worked with. If you do it too late, you don't know what to answer.
Yeah, exactly.
You don't know what the jury wants until it's too late to get it through discovery.
100%. I think in a perfect world, on a large case, not the case I lost where I should have taken the money, but in a perfect world, in a large case, you're doing a couple of focus groups. And the final one is just basically a test run of all your evidence. But by that point, you're not able to correct much. So you're right. By that point, you're just going, I hope we got it right, to a degree. And then you asked about jury consultants. So I swear by Claire Plotkin. She's been excellent. She was on both of those cases. My recollection is that, and don't quote me, that I was introduced to the idea of the Plotkins towards Harry. and Harry wasn't available. And I ended up with Claire, I believe. This is my recollection of it. It was a while ago. And I never looking back. Harry seems like a very nice guy, but Claire Plotkin is awesome. And Claire Plotkin is awesome, one, because she's really smart, really understands the dynamics of a jury trial. And two, she has no qualms about telling me I'm wrong. And I appreciate that. And I listen to her.
On that front, do you have her there during the selection itself?
Yes.
And when she's telling you you're wrong, how do you engage with her in that kind of rapid fire way that you have to handle jury selection?
I've moved past it and I've just said, I'm just going to have you say what you think first because I'm going to agree with it. So she doesn't get to tell me I'm wrong that much anymore.
Makes sense.
Because she knows what she's doing. And again, it goes to the village approach, which I think just, you can't have, again, a consultant on every case because not every case warrants all of these different things. Like if you're pulling out all the stops and then you're going to have a big ask on a case and you think it's a case that supports a big ask, those are the focus groups, the consultants, all those things. Those are like in a perfect world where we're doing all of that. Because what I found is if you go into a trial without a consultant, without a clear jury selection plan, without a questionnaire, maybe because the judge won't give it to you, which is not uncommon in my experience, you end up in a whole different world than if you do go with all those things, I think. And I think you can obviously still lose cases when you can lose a case when you do everything right. It's a good case and all that, because there's still some degree of it all has to come together and the jury has to be ready to reach that result, but I think Claire is amazing and I highly recommend her. So anyone wants her information, don't hesitate.
You mentioned Zoom, and one of the questions I love asking people is whether they're back in office 100% as far as everyone in the office, whether they're hybrid. How have you personally and then your firm approached that work environment?
I think I am like the totally different, not to malign my generation and age group. I think a lot of people in my age group, particularly when it started to be work from home and all that, they really took to it and they really liked it. I hated it from moment one. I really did. And maybe I was just a curmudgeon before I knew it and before my time, but I'm still the same. And the issue I have with it, so we're all back in the office. We work in person. I felt like looking back, I would not have developed, because you talk about, your background at the Veen firm and having these strong mentors. You need strong mentors when you're a young lawyer, especially in your first few years, because you don't know what you don't know. And I just remember being terrified all the time. And I was competitive and was willing to fight, but I was also scared about the other side knows so much more than me in depth of knowledge. And it takes a while to develop that depth. So I could always just go into Mike Green's office and he was someone who he was always right there. And it's like we had offices next to each other. That's different than being like, okay, can I call him? What's he doing? Can I text him? Oh, let's set a Zoom meeting for tomorrow. Like, I just don't think I would have developed in the same manner. And I don't think that my associates would develop in the same manner. So I think that you're doing yourself a disservice when you, especially for younger lawyers, when you aren't all there together collaborating. Does that mean that we don't have people that work from home certain days? No, absolutely not. Of course we do. My paralegal Haley works from home some. There's other people in the office who work from home some. We accommodate, and I deeply believe in accommodating and caring for family. That's super important to me. But if you were to say, like, how are you best going to develop your team? How do you best serve your clients? So not just your team, the clients, but the whole thing. It's being there and collaborating with other people, eye to eye. Even though for Zoom and focus groups and things, those are great because they allow us to have more people, have conversations, but I'm not trying to develop those people as a lawyer or trying to, put together a complex case. So we're big on in the office, collaborating, working together, again, with exceptions for humanity's sake, so to speak.
Thank you for listening. And please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.